Hello and welcome to my presentation on US ICC relations. This presentation will look at the relationship from the formation of the ICC through the Rome Statute up until the current day, where we're on the verge of entering the Biden administration. There were the Nuremberg and Tokyo trials in the aftermath of the Second World War, but any real prospect for an international criminal court disappeared with the advent of the Cold War. There simply wouldn't be any consensus between the two opposing blocs, with each side feeling the other would simply try and use the court as a weapon. It wasn't until the 90s that the prospect of such a court became a realistic option. The International Law Commission was at work on a draft statute, and this would be finalised in 1994, and this would in turn go on to form the basis for the 1998 Rome Statute and eventual formation of the ICC. In the meantime, ad hoc courts were set up to deal with various situations, such as in Yugoslavia, Rwanda and Cambodia, and all of these were heavily supported by the United States. The Rome Statute was finalised in July of 1998 and would eventually come into force in July of 2002, when it received 60 ratifications. At the initial signing of the Rome Statute, 120 countries voted for, there was 21 abstentions, and 7 voted against. These 7 were Iraq, Israel, Libya, China, Qatar, Yemen, and the United States. Although President Clinton would later sign the Rome Statute in 2000, there were strong concerns among the Americans relating to the ICC. In the run-up to the signing of the Rome Statute, the main concern was how the crime of aggression would be defined, and subsequently the main issue moved to what was the jurisdiction of the ICC. Essentially, what were the trigger mechanisms to bring one of the crimes under the jurisdiction of the ICC. So firstly, on the issue of aggression, an expansive definition would call into question many US actions across the world. Would the bombings of Sudan, Iraq and Yugoslavia be acceptable uses of force under this Rome Statute? Would the US enjoy the same leeway it enjoyed under Article 51 of the UN Charter? Many of the larger countries shared these same reservations, and as a result no consensus was going to be found. Instead, it was decided to exclude a definition on the crime of aggression. Instead, a special working group was established to formulate proposals on a future definition. This process would later culminate in Kampala in 2010 under the Obama administration, which I'll be discussing later. The issue of jurisdiction raised concerns for the Americans, as even being a non-party state did not preclude the possibility of prosecution for its citizens. The 3 principal trigger mechanisms by which the ICC jurisdiction can be employed is set out in Article 13. Firstly, under Article 13.1, there is a state party referral, by which a state party either refers itself or another member for investigation. Examples would include Uganda in 2003 as a self-referral, or as another country referring another country would be Venezuela, when it was referred in 2018 by a number of other South American states. Secondly, under Article 13.2, there can be a Security Council referral. Examples of this would be Darfur in 2005 or Libya in 2011. Finally, under Article 13.3, there is the ability of the prosecutor to initiate an investigation themselves, although this is subject to satisfying a pre-trial chamber, as laid out in Article 15. Examples of prosecutor-initiated investigations can be seen in Kenya 2010 or Georgia 2016. So American nationals are naturally safe with regards to a Security Council reference, as they hold veto, but the situation becomes troublesome regards the other 2 trigger mechanisms. If a state party is referred either by itself, another state party, or the prosecutor, any nationals in that territory are liable for prosecution, irrespective of if they come from a non-party state. The Bush administration would have a pretty contentious relationship with the ICC. 1 month before the ICC was going to come into force, the administration sent a letter to the UN Secretary General Kofi Annan stating that they would not be ratifying the Rome Statute, and furthermore they were withdrawing the original signature given by the previous Clinton administration. This was to escape from any obligations under the Vienna Convention, as under Article 18 you're obliged not to undermine any treaty you've signed prior to ratification. On the same day that the ICC came into being, President Bush signed the American Service Members Protection Act into law. This was directly aimed at subverting the ICC. It had a number of provisions. Firstly, it would prohibit any cooperation with the court in relation to US nationals, be it in the shape of providing finance, facilitating extradition or supporting investigations. Secondly, it barred any US participation in UN peacekeeping missions unless unless US personnel were granted exemptions from prosecution. It allowed for the restriction of US aid to countries who refused to sign Article 98 agreements. More on those later. Initially, these restrictions were confined primarily to certain military aid, but was extended to economic support funds with the Neither Cut Amendment. Finally, provided the President authorization to use all means necessary, appropriate to bring about the release of US or allied persons who were detained by the ICC. The administration would use elements of this act to force nations to conclude bilateral immunity agreements, BIAs, where countries would essentially agree not to surrender any US nationals to the ICC. These were made possible by the exploitation of Article 98 of the Rome Statute. Its original purpose was to allow countries to respect extradition treaties between countries. It was intended to deal with inconsistencies where a country would have a simultaneous obligation to surrender an individual to both the ICC and their home state. NATO members and major US allies like Australia and South Korea were excluded from this. The Bush administration sought to clarify the law surrounding the various aspects of the war on terror. Firstly, what laws govern the capture and detention of captured Al-Qaeda or Taliban members. Secondly, how the current laws revolving around torture would apply to their treatment in captivity, and more specifically, any obstacles posed by the Geneva Convention Against Torture and any domestic federal laws, such as the Torture Act. These questions were posed after a request to apply enhanced interrogation techniques to Abu Zubaydah, a detainee in Guantanamo Bay. In a series of infamous correspondences known as the torture memos, the Office of Legal Counsel would provide the administration with the legal basis to essentially circumvent the Geneva Convention on Torture and domestic federal laws. So to look at a US federal law and the Torture Act as an example of how far the Office of Legal Counsel were willing to stretch the law. Section 2340A defines torture as an act specifically intended to inflict severe physical or mental pain or suffering. The definition given by the Office of Legal Counsel held that severe physical pain as damage that must rise to the level of death, organ failure, or permanent impairment of a significant bodily function. This is clearly a questionable interpretation. Next, the invasion of Iraq and subsequent occupation brought about a lot of human rights incidents and allegations of war crimes. Perhaps the highest profile incident was the human rights abuses and torture at Abu Ghraib prison. None of these incidents were within the ICC jurisdiction, as neither the US or Iraq were obviously members. However, it is interesting to examine one of the primary arguments of US officials for not joining the ICC, in that the US is perfectly able to prosecute its own war criminals. Testifying before Congress in the aftermath of the scandal, Defense Secretary Rumsfeld stated, "Watch how democracy deals with wrongdoing." In reality, no real senior personnel faced any consequences. Later, senior figures like Rumsfeld and General Sanchez would later be heavily criticised in a Senate report for authorising aggressive interrogation techniques, with the report explicitly citing Rumsfeld's actions as being a direct cause of detainee abuse. In respect of the Obama administration's relationship with the ICC, the Kampala conference was the most significant interaction. The primary purpose of the conference was to finally get a consensus on the definition of the crime of aggression. The same issues remain since '98 for the Americans. Firstly, that the definition they wanted it to be as loose as possible, and secondly, that the jurisdiction for the crime was be as restricted as possible. On the issue of the actual definition, the worst case scenario would be a strict definition that went beyond the latitude afforded by Article 51 on self-defense under the UN Charter. In the past, they have used this to justify the assassination of Osama bin Laden, and lately of the Iranian general Qasem Soleimani. America even uses Article 51 to justify drone strikes. The amendment would define the crime as an act of aggression which, by its character, gravity and scale, constitutes a manifest violation of the Charter of the United Nations. As such, the United States had a real concern that the definition was inextricably linked to that of the UN Charter and therefore Article 51. The US would propose an attachment of an understanding to the amendment in a bid to render the definition even looser, or in the minds of some scholars, in a bid to completely neuter it. The understanding would require that any act must not just be a manifest violation of the Charter, but must be a manifest violation of the character, gravity, and scale. They had hoped for more concrete safeguards, such as an explicit mention of an exception for forcible humanitarian interventions, but this was rejected, and given the concessions already garnered, not strictly necessary. The US gained even more safeguards with respect to the ICC jurisdiction to prosecute the crime, in that the nationals of non-parties could not be prosecuted. Even if the national was on the territory of a state that had ratified, they still could not be prosecuted, unlike other crimes under the ICC's remit. The only exception to this is the Security Council trigger mechanism, where non-parties can be brought under the jurisdiction of the ICC for the crime of aggression. But as the US has a veto, this doesn't really matter. The position as it currently stands gives the US complete protections for its nationals. On top of this, the whole process was put forward until January 2017, where it would require two-thirds approval, along with the subsequent ratification by 30 member states. This process was completed 2 years ago, and since 2018, the ICC can prosecute for the crime of aggression. Whilst the Obama years saw a significant level of engagement with the ICC in comparison to the previous Bush administration, they were largely getting what they wanted in regards to US interests. Some might say, why were they afforded such influence at, say, Kampala, when they weren't even a state party? So it's important to note that the other major players of the negotiations knew the significance of having the US as part of the process. It not just adds credibility to the ICC, but can be seen as perhaps a building block on the path to eventually the US joining, however unlikely that may seem. Also important to point out, it's not just the US against all the other state parties in these negotiations. Be it in 98 or Kampala, their concerns are usually shared by others, such as the UK and France, in particular when it came to the crimes of aggression. Despite engagement, the Obama administration did pursue many policies that were questionable from an international human rights perspective. They significantly ramped up the use of drone strikes from the Bush years, even on a couple of stages ordering strikes on US citizens in the Middle East without anything resembling a trial. Also, the administration refused to consider to prosecute any individuals for war crimes from the previous administration, and continued to protect such individuals during their own administration, such as when they shielded former CIA station chief for Milan, Robert Lady, from Italian authorities in 2013. The Trump administration would see our relations plummet to levels even worse than those under the Bush years. This is hardly surprising given the administration's America First anti-globalist agenda. They would pull out the Paris Climate Accords, the UN Human Rights Council, and virtually cripple the World Trade Organization. This was an administration that would pardon convicted war criminals and subsequently bring them on stage at campaign rallies, while referring to them as American warriors and American heroes. Any positive engagement with the ICC was simply not going to happen. In late 2017, ICC prosecutor Bensouda, using her authority under Article 13, would petition the pre-trial chamber for authorization to pursue an investigation into the alleged crimes that took place in Afghanistan. The investigation will cover alleged crimes of the Taliban, the Afghan National Security Forces, and those of US forces, dating from Afghan ratification of the Rome Statute in February of 2003. This investigation would even extend to other state parties in relation to CIA activity where individuals were allegedly transferred to secret detention facilities in Poland, Romania and Lithuania. The alleged crimes set out in the prosecutor's preliminary report pointed to a dramatic lack of accountability and failure of both the military and civilian and judiciaries to prosecute these crimes in the United States. The application was rejected by a pretrial chamber in April of 2019, despite satisfying key aspects such as would come under the jurisdiction of the ICC and was the case admissible. The court judging that any furtherance of such an action would not serve the interests of justice. Expanding on this line of reasoning, the chamber cited the overall volatility of the political climate and minimal cooperation from the relevant authorities as key factors in the decision. The political volatility referenced was displayed by the US decision to directly target the ICC prosecutor by revoking her visa 1 week prior to the decision. The decision not to proceed was widely criticised, as it gave credence to the accusations that the court would always bow to pressure from Western powers and was only ever going to prosecute African crimes. This could have set a blueprint where other countries with sufficient power and influence could simply stonewall any investigations and bully the ICC until it eventually resigned itself to defeat. On the 5th of March 2020, the decision was successfully appealed to the ICC Appeals Chamber, and permission to launch a formal investigation was granted. The appeals chamber held whether a case was within the confines of the interests of justice was one for the prosecutor to determine, and the pre-trial chamber erred in its interpretation on the matter. This would be followed by more US sanctions, with the president signing an executive order which targeted any non-US ICC persons acting in any capacity in an ICC investigation of US nationals. Any such individuals would be put on a specially designated nationals list and subject to travel restrictions, and these restrictions could even extend to financial sanctions such as the seizure of assets. So what does the future hold for US ICC relations? There will be a new president in January, Joe Biden. It's understood he will drop all sanctions on the ICC literally on the first day of office. Realistically, the relationship should revert back to how it was under Obama. It should be noted that the prospects of the US joining the ICC in the near to medium term are virtually zero. A Republican president would never join, and even if a Democratic president wanted to, getting a true Senate isn't realistic. Republicans will go crazy saying the Democrats want to leave our troops open to prosecution by a foreign court that can be influenced by our enemies. It's just completely unrealistic that could pass. Finally, it will be interesting to see how the US reacts to the progression of the Afghanistan case. The Obama administration never faced a situation like that. It's hard to imagine any US administration, even a Democratic one, cooperating with any external investigation of its nationals. So it'll be interesting to see how that progresses.